Now let's talk about mandatory qualifications. Um, any required qualification for employment is unlawful if it has an adverse impact on a protected group, unless the employer can show that the requirement is job-related and consistent with business necessity. Some examples of that are, for instance, the famous case against Duke Power Company that required a high school diploma for all the people that worked in maintenance. Well, high school diplomas are normally, or at least statistically speaking, may disproportionately exclude certain racial groups. So the EOC, and you all maybe heard about the case that the newest Supreme Court judge dealt with in New Haven, Connecticut, and that was talking about, a disparate impact on certain groups. So if you have mandatory qualifications for a job, you need to make sure they are job related and consistent with business necessity. Let's talk about some more of the mandatory qualification issues or requirement issues. First is arrest or conviction record. This is probably the biggest source of misconceptions I see in the hiring process. I read a lot of applications that simply ask if somebody's been convicted of a felony. The problem with that question is that means if somebody, for instance, pled guilty to first-degree murder, they don't have to answer yes on your application. Let me tell you why a lot of people have misconceptions about this, and then let's talk about what I recommend. All the way back in 1990, the EOC issued a policy opinion that asking about arrest or conviction records had an adverse impact on minorities because minorities are more likely than non-minorities to be arrested. They also said that you can look at arrest or conviction records to determine if it's reasonably related to the job. Now, there are certain states, let's take California for instance, that says you can't ask about certain arrest or conviction records, and you can only ask about convictions for felonies. You can't ask, for instance, about marijuana arrests. Florida, for you all who only have employees in Florida, Florida doesn't have any such rule. So you absolutely can ask about arrest or conviction records. You certainly would probably want to know, if OJ was applying to work for you, he was found not guilty. But at the same time, wouldn't you want to know about his arrest record in making a decision if he was the right person for the job? As far as my recommendation goes, I would again ask the question on your application about arrest or conviction record. I'd also confirm that using some sort of background check to find out, sometimes people lie on their applications, as I'm sure you all have run into before. They lie because maybe something happened a long time ago, or they thought it was expunged, or they entered some sort of pre-trial intervention, so they weren't technically convicted, so they may not tell the truth on their application. But you all would want to know about that. There's nothing wrong, at least in Florida, about asking arrest or a conviction record. But again, once you find out if the answer to that question is yes, use some common sense and decide if it's job-related. If somebody was arrested for using a fake ID 30 years ago in college, it may not be all that relevant to them working as a receptionist for you now. But if they're going to drive your company van and they were charged with the DUI but pled it down to a reckless driving, that's certainly something you'd want to know about. Next is weightlifting ability. Again, this may have a disparate impact on females. The EOC in some courts has specifically said that a male-only position, because the position requires some sort of heavy lifting, is a violation of the law. So if there are weightlifting abilities that's a requirement of the job, you've got to keep it open to both men and women. And again, you've got to make sure that the ability to lift a certain amount of weight is actually job necessary. Same thing goes with minimum or maximum height and weight requirements. These can be unlawful. There are certain racial groups or national origin groups who are shorter or taller or weigh more or less. You want to make sure that they're truly related to the job. Some people don't want to hire folks that have a garnishment history or a credit rating problem or bankruptcy. There are laws dealing with these type of situations. I don't have time to get into all of them, but I will say make sure you look long and hard before you tell an applicant they're not welcome to work for you simply because they have some sort of bankruptcy or credit problem or garnishment history. Education's a big problem for many employers. The EOC and many courts do not like education requirements. So if you're requiring a college degree or a high school education, make sure that it's truly necessary for the job and you can explain why that's necessary. Grooming standards are another issue that I see come up quite a bit. Grooming standards are allowed. Here are the caveats, though. For instance, if you were hiring somebody that was a Muslim and they wanted to, a Muslim female, and they wanted to wear something on their head, a hijab, for instance, unless you can show that that would affect the health or safety of the organization, then you're probably going to have to allow them to go outside your normal rules. Another example would be many religions call for females, for instance, to have a nose ring. You may want to have a policy that there can be no facial jewelry. You have to make exceptions for religious beliefs and be very, very careful about that. There are some famous cases, for instance, companies that say you can't have a beard, where religious folks or even racial groups who have beards for a litany of different reasons have to be allowed to keep their beards. Citizenship is another issue. You can decline under at least Title VII of the 1964 Civil Rights Act. That's not a protected category, but what's called IRCA, or the Immigration Reform and Control Act, does deal with citizenship. That's different between having the ability to work for you and what their actual citizenship is. So I wouldn't recommend not hiring somebody simply because of their citizenship. Language requirements are something we see quite a bit in Florida. There's nothing wrong with saying that somebody has to be fluent in a particular language. For instance, if you're in a Hispanic neighborhood, you may require somebody to be able to speak with whoever the customers may be. But you need to be very careful and make sure that those are job necessary. Some of the issues we also run into deal with job postings as well as whether or not to internally or externally advertise. I normally recommend, if you have a job opening, to first post it internally, whether it be on an internet system within your company or an email to all of your employees or on a bulletin board. I run into a lot of people that say, I was overlooked for a position or I was overlooked for a promotion, and it was never inquired. If you have an opportunity or ability to post something internally, I think that's extremely important. Let's also talk about external advertising, because this gets folks into quite a lot of problems. Federal law prohibits stating preferences in a job application based upon someone's race, color, religion, sex, national origin, or age. So you want to make sure, I'm sure none of y'all do this, but you want to make sure, for instance, you don't want to have advertising that says something like recent college graduate. Typically, recent college graduates are very young, and it may show a preference towards age. So be careful about things like that.